If you want me to have a go at Blair and Brown, I will later on in the question and answer session. But the point is that these were the instruments of international law that Turkey busily violated and had no ethical qualms about violating in 1974. And their actions in mid-August 1974 were completely inexcusable, grossly disproportionate, and clearly unlawful. Now, I hear on LGR and on various, and on RIC, they talk about the diploenglima, the double crime. And I think that is an inappropriate use of terminology. The coup was, in Thucydidean terms, the mere pretext for Turkey to come in. And I want to take you back to Thucydides, and Thucydides as the English call him, and his great book on the Peloponnesian War. This was something that was drummed into me when I was a school child, and I've never forgotten it. In the Peloponnesian, in the origins of the Peloponnesian Wars, Thucydides draws a crucial distinction between the publicly expressed grounds for complaint prior to a war and the real cause of the war. And when I hear on Rick the diploenglima, it's as if we're falling into the Thucydidean trap of treating the pretext as the real cause. The pretext is the dressing up that the invading power uses in order to justify something that they've already got in their mind. Think of the invasion of Iraq in 2003. Did we really invade Iraq because Iraq had weapons of mass destruction? Was that the real reason, or was that the pretext? And it transpired they didn't have any weapons of mass destruction either, or at least none has been found to date. None have been found to date. Back to ethics. What about, who have I left out? I mentioned the junta, I've mentioned Turkey. Who have I left out? My country of birth, the United Kingdom. We mustn't overlook the United Kingdom. Under the Treaty of Guarantee, the United Kingdom, in tandem with Greece and Turkey, undertook, note the wording from Article 2 of the Treaty of Guarantee, they undertook to recognise and guarantee the independence, territorial integrity, and security of the Republic of Cyprus, and also the state of affairs established by the 1960 Constitution. Accordingly, the United Kingdom was under a legal and moral duty, which in 1974 it clearly failed to observe. Leaving aside the law, I'm going to leave aside the law because that's not my theme this evening, the failure to honour the guarantee was unethical, was it not? And I judged the British by higher standards than Greece and Turkey. The British are honourable, the British are gentlemen, and I have some ladies today in government, but back then it was right honourable men who were in power. I would go one step further and say that British policy in 1974 was, to borrow a phrase drawn from our English law of equity, unconscionable. Indeed, British policy in 1974 was un-British. It was ungallant. It was ungentlemanly. In short, it wasn't cricket. I played cricket on Sunday, as I do, and on the wall of the changing room there's an extract from the preamble of the laws of cricket from the MCC, and it calls on cricketers not only to observe the laws of cricket, but to observe the spirit of the laws of cricket. That is how English gentlemen in the days of the 50s, 60s and 70s, that is how English gentlemen were brought up. And in 1974, the British ought to have known better. And I know that the armed forces, many in the armed forces were prepared to honour the guarantee, but the Prime Minister and the Foreign Secretary chickened out because they were afraid of upsetting the Americans and offending the Turks. And in traditional English gentlemanly terms, there's nothing worse than being a coward. So I regret to say this about the UK, a country I love, but in 1974, the British acted in an un-British, ungentlemanly, ungallant, unethical, and unconscionable way. And remember, the Prime Minister was a right honourable gentleman back then. Now, having said all of that, let me just say one final point about the undertaking before I move to the penultimate theme of my talk. I know from experience as a solicitor, now a non-practicing solicitor, that when a solicitor gives an undertaking, he must honour it. not just a matter of law or professional conduct, it's a matter of personal honour. Now, I warned the organisers of Lobby for Cyprus that I'd be late, and I'd arrive at around 8:30, but I honoured my undertaking. Did I honour it because I was under any legal obligation to honour it? Was I under any professional regulatory duty to honour it? Or was it because I had personal honour? And that's my point, ladies and gentlemen. This is missing in Cyprus. Honour, dignity, humanity. These concepts are missing, and we need to ensure that they are gradually entrenched within the conscience and the psyche of all of the politicians in the region and within every citizen. That's easier said than done. That's what's absolutely necessary, and we've forgotten about it in recent years. Let me now just say a few words about the moral conscience of a state. Now, I've attacked the British, and we know they engaged in colonialism and slavery, and they engaged in the invasion of Egypt in 1956, and they were involved in Iraq in 2003. But having said all of that, I would argue that beneath the British stiff upper lip, one finds a beating heart and a moral conscience. It's especially the case in the judiciary, but I would say it's also the case in the political class. Let me just illustrate the point. Earlier this year, the British Prime Minister Gordon Brown, the then British Prime Minister, issued an apology to the House of Commons for what he described as the misguided and shameful Commonwealth child migration schemes which existed up to the 1960s. This involved Australia, so there was an international relations element to it. He went to the House of Commons and he issued an apology on behalf of the nation, and it was accepted by all of the parties.